It's incredibly important to have a comprehensive estate plan to protect both you and the beneficiaries of your estate. Making sure that your plan has the documents that will take care of you while you're alive, organize your assets properly, and distribute out to your beneficiaries is important to make sure that you are being tax efficient and dealing with the fact that your beneficiaries themselves may have a disability or be on government benefits. Without a proper estate plan, you are subjecting your estate to the default rules of New York and leaving an estate that does not have the proper protections of trusts for your beneficiaries to protect them further. A proper estate plan should involve several documents. First, we talk about advance directives. These are healthcare documents that are signed now in advance of needing them to ensure that your wishes are followed if you should be unable to express your own desires regarding your medical treatment. This often includes a healthcare proxy and a living will. A healthcare proxy is a document that states who will make medical decisions for you if you are unable to make them for yourself. It is a document that should also list if your agent is able to make decisions regarding end of life, including artificial nutrition and hydration. A living will is a document that states whether or not you would want certain measures taken if you are in an irreversible state with no reasonable expectation of recovery. This could include kidney dialysis, cardiopulmonary resuscitation, and other types of treatment. Both of those documents are to be signed in front of 2 witnesses. In addition to the medical directives, a comprehensive estate plan will also include a durable power of attorney written and reviewed by an attorney to make sure that it has all of the various powers that might become necessary should you be unable to handle all of your affairs by yourself. Not all powers of attorney are created equal. A power of attorney or an agent named under a power of attorney only has the specific powers that are listed in the document. If you specifically want your agent to be able to sell your real estate, access your bank accounts, or transfer assets out of your name, all of these are specific powers which must be listed in the document. Meeting with an estate planning attorney, you should be telling them what your goals are, and they should help you accomplish those goals. Who are you most worried about? Is it your daughter? Is it your favorite charity? And how do we make sure that your assets are transferred to that person or that institution in the best way possible after your death? A comprehensive estate plan deals with various documents, those that are in effect while you're alive and ones that take effect at your death. There are the advance directives, which are healthcare documents. They talk about who will make medical decisions if you can't make them for yourself. We put that into a healthcare proxy. And a living will. What kind of decisions would you want that person to make for you? Would you want to be DNR, do not resuscitate? Would you want treatment to be stopped if you were in an irreversible state with no expectation of recovery? Since these documents are utilized in the future, you are signing them now in advance of that time, which is why they're called advance directives, so that you can keep control over those types of decisions even when you're not able to voice them at that time. Most importantly, you should be discussing with your advisors who is the best person to name as your healthcare agent. Who is it that would make decisions in line with those that you would make if you could speak for yourself? After we worry about your medical, we also worry about financial. So while you're still alive, you would have a power of attorney. The agent named under the power of attorney document could be responsible for things such as paying bills on your behalf, selling your house, moving assets into a trust, or other gifting or transfer of assets on your behalf. However, seeing an attorney and discussing exactly what powers to give to an agent under your power of attorney is really important, because you need to understand the implications, both positive and negative, about giving these powers over your estate while you're still alive to another person. And so your power of attorney document should be drafted by an attorney in consultation with you to understand exactly what you're concerned about someone handling for you in the future, and making sure that those powers are given in the power of attorney document. Not all power of attorneys are created equally. So that, when I say that, what I mean is that if the power isn't specifically listed in the document as a power you're granting to the agent you're naming, then they don't have the power. And so you really want to think about who to name as agent. Do you trust this person? And what do you trust them with? And what makes you uncomfortable? And with this information, you and your attorney can really craft the best power of attorney document for you. The other common document that we talk about in estate planning is a last will and testament. A last will and testament talks about what you want to happen with your assets when you die and who is to be in charge. We call that the executor. A last will and testament at your death will need to go through a process called probate. A last will and testament will say exactly what should happen with your assets. So for example, you may have specific dollar amounts that you want to go to your favorite niece or to a charity. And then we have what's called your residuary, which is the bulk of your estate. And where is that going to go? Maybe it's to be divided equally amongst your children, or to go to other various institutions or charities that you want to support. Understanding who your beneficiaries are, who you're looking to give things to, will help an attorney describe to you the best way to structure that document and to structure your estate. The will is going to control everything in your sole name without a beneficiary. So if you have, let's say, an IRA, retirement account, or a life insurance policy where you've named a beneficiary, the will is not going to control those assets. So when I talk about a comprehensive estate plan, it's really important that you tell your lawyer what all of your assets are and if there's any beneficiaries named on them, or if you have joint owners. Because for example, if you have an intention that the bulk of your estate go to one specific person, but there's beneficiary designations on all the different assets, your estate may not end up going where you want it to go at your death. So having a consultation with an estate planning attorney in which they go through with you who all your beneficiaries are and what all of your assets are is imperative to having an estate plan that is going to work in the end. Some people also create a trust. Now, getting into trusts is a very big topic. There are many different types of trusts. And again, discussing your goals with your estate planning attorney is going to tell you what type of trust you need. Do you have a disabled child or other beneficiary? That might create a situation where you need to be creating a supplemental needs trust or a special needs trust. Are you looking to protect assets from estate taxes? So we might be creating an insurance trust or other trust that is irrevocable that will protect against estate taxes. Or are you concerned about the costs of long-term care and are looking to protect assets in a trust to gain Medicaid eligibility to assist with payments of long-term home care or nursing home care, in which case you would make an irrevocable Medicaid asset protection trust. So again, getting to the core of what your concerns are, what your goals are, and who you're looking to benefit will help us determine if you need a trust and what type of trust you might need to create. Very commonly, clients will create revocable trusts for the purpose of avoiding probate, avoiding that court process after death where the will is subject to court scrutiny and objections from your family members. So this is another type of trust that we're often discussing with clients to help them understand if it suits their needs. Having an attorney assist you with an estate plan is really important. There are a lot of moving parts and a lot of things that can go wrong. With the advice and counsel of an attorney, you can understand what is most important to have in the documents, and they can anticipate for you circumstances that might be beyond your knowledge or understanding. For example, very often when creating a will with a client, we're talking about who the beneficiary is. But then I ask them, well, what happens if that beneficiary is not around? Then who takes next? And very often clients don't go beyond that first line when thinking about it on their own, because they can't even fathom of the fact that their child or grandchild or other beneficiary that's younger than them may die before them. But as estate planning attorneys, we look at all of the different possible scenarios and make sure that they are accounted for. There's also a chance that that one beneficiary might be disabled, or perhaps they're a minor. And without the counseling of an attorney and without the attorney properly drafting the documents, you may not be creating a situation that's in the best interest of that minor or disabled child, because they don't have the ability to handle the funds on their own upon your death. Without discussing your estate plan with an attorney, it's very hard for an individual to determine on their own if they are in need of a trust of any kind, or if a last will and testament will suffice for their estate plan. Very often, individuals do not understand the process of probate and the individuals that would be required to be notified of probate. And discussing that with your attorney and understanding what it will look like upon your passing and what actually will have to be done can give you a better understanding of what documents you actually need. At Burner Prudenti Law, we work collaboratively with our attorneys and support staff to make sure that our clients get the support they need as they're making these very difficult decisions about their future. Often we're discussing with clients what will happen upon their death, or should they become disabled or mentally incapacitated. And these are hard conversations. And here at Burner Prudenti Law, we pride ourselves in the compassion that we give to our clients while giving them sound legal advice to come to the right solutions for them and their family members.